these rights, and you can do it in a way that makes economic sense. The other mistake that I often see people make is giving the condemning agency's agents information and access to your property informally. Long before these eminent domain cases are filed, a whole series of agents, of the condemning agents, are crawling all over your property like it's an anthill. So there are biologists and appraisers and engineers and geotechnical people and archaeologists and everybody else you can think of. And it's kind of like the camel's nose under the tent. Once they get in there, they're walking around like they own the place, and they're coming and going. And they're always asking you for information about your property. I recommend that you not provide that information. You can always choose to provide it later, but it's a mistake to open, your books this early in the game, because once you tell them things, you can't take it back. And also, one of the problems is sometimes they tend to hear what they want to hear. So if you tell them something that's helpful to you, it kind of goes right over the head. But if you tell them something that they think might help their position, it gets documented, and then 2 years later it comes out, well, Mr. Smith admitted in his driveway that, whatever. So you need to be very cautious. These people, I don't mean to paint them as being bad people, but they got a job to do. They're trying to get this done fast and cheap. And one of the expenses in these projects is the cost of the right-of-way. So that's a major component. And they're under a lot of pressure to do this on time and on budget. What I would suggest is when you're approached like that, don't waive any of your rights. Don't give anything up, and you don't need to rant and rave about it. You can be very professional and polite. You just say firmly no. I oftentimes consult with property owners far in advance of when an eminent domain case starts, and I do it for no charge and at no obligation. It helps me to keep my finger on the pulse of projects like this. And what it does is it takes the property owner off the hook of having to respond to all these questions in real time. So one day you get a knock on the door and a civil engineer wants to bang on the driveway, and the next day somebody wants to look for fossils, and they're always in a big hurry. They come storming in like Chicken Little, telling you that if they don't get this done by Wednesday, the sky's going to fall. The fact that they have scheduling problems is not your problem, okay? Their crisis should not be yours. So the way you handle that, what I would recommend, is you politely say, I'm not agreeing to anything. If you want something from me, please put it in writing. I'm consulting with an attorney. I'll consider your request and I'll get back to you. That way you don't need to make any decisions right then. You can call me, you can call anybody else you want, you can call nobody. You can sit down and have a cup of coffee and then call them back when you feel like it. But you don't have to respond to their time frame. Now, you should get legal advice early. You should do it from someone who specializes in eminent domain. If possible, you should minimize any expenses that you incur early in the case. You want to spend as little money as possible out of pocket on these cases, and if you do have to spend something, you want to defer it and spend it later. Now, the preliminary consultations that I'm involved in are free of charge. If you decide to hire me later, I typically work on a contingency fee basis, which means that whatever I can get you above and beyond what SDG&E says you're entitled to, I share in that. If I can't get you anything over what they've already offered you, then there are no attorney's fees. So there's really no downside to finding out what your rights are. And if this drags on, I'm working on cases, freeway cases that they came storming through saying they wanted to build this thing, yesterday, and they've been planning them for 20 or 30 years. So who knows when it's going to happen. It might happen tomorrow, it might happen next year, it might happen 10 years from now. We maybe all be dead and gone when it happens. But whenever you have a question, feel free to call. Now, the other thing you should avoid is hiring an appraiser very early in the case who is not familiar with the unique rules of eminent domain, paying him, because these are expensive appraisals. You know, they're forensic appraisers, which are not typical ones that you get for a bank. You don't pay these guys $300 to drive by, you know, like you do for a loan, because these are expert witnesses that can stand up in court and be effective, and they're much more expensive. So first of all, you get someone who knows eminent domain, again, you don't spend the money until you have to. A lot of people run out and get appraisals early on, then they end up doing a reappraisal a year later, it costs them more money than it should have, and if the appraiser rarely says the exact same thing twice because he looks at it a little bit differently, and then he gets impeached with every little discrepancy. It's just a big headache. You're shooting yourself in the foot. Okay, so I would recommend deferring on that. Now, SDG&E should be offering to reimburse you up to $5,000 for your own appraisal. The problem is that if they give you the $5,000, they act like it's their appraisal. So they attach conditions to it. Sure, we'll pay you $5,000. Just show us the report right now. That is a mistake. Okay, you're entitled to the $5,000 for your appraisal. I recommend deferring accepting the $5,000 until you're ready to exchange these reports. You know, there are tactical reasons why they don't show you their appraisal, but they want to see yours. So I would hold off on that. The other thing you should avoid is being drawn into negotiations where you make specific counter offers to their offers before you really understand what you're dealing with. Okay, because you're going to have to live with the result. So if you start negotiating thinking the impacts to your property are one thing, and then it turns out there's something totally different, you've dug yourself into a hole. So what you do is you don't waive any rights, you don't give anything away, and you learn as much as you can about this project and about your rights. You know, what exactly they're going to be doing out there. Oftentimes, the plans are vague. I mean, you look at these maps, and I mean, I don't know what they say. I can't read them. I don't know exactly how it's going to affect specific property. A lot of the scales are so big that they're not site-specific. And so you need to keep asking the question, exactly what are you doing and when are you going to do it? And are these plans final? Because that's when the backpedaling starts. You know, this can often be a moving target. Now the steps in an eminent domain case. It's very mechanical. So these things are very predictable. I told you that the time frame is a bit uncertain because a lot of times it's hurry up and wait. They'll come screaming into your yard one day telling you we're doing this tomorrow, and then they'll disappear and you won't hear from them for months or years, and then they'll come in again all hot. And so it's hard to say how fast this is going to go, but they do have to go in certain order of steps, and they can't go to step 2 until they've done step 1. So you can see them coming long before these things develop, okay? So the first thing they're supposed to be doing is making you a fair offer for your property. Now, we've heard some real concerns about what we call preeminent domain activities by SDG&E. That is, before the case even starts, they're out there snooping around. Now, they've got an obligation to make you an offer, and in order to do that, you know, they want to come out and look at the property. So there are some legitimate needs to do that, but they're supposed to do it without any coercion or manipulation or misleading statements, and they're supposed to do what